Hello, friends. I'm Amol, and I hope that all of you are doing well and keeping safe. In today's episode of Sunday Boosters, we will discuss some aspects of non compete and non solicit clauses in commercial contracts. Non compete and non solicit clauses in commercial contracts, in my opinion, are most desirable for the parties who are continuing with the business and considered as a hindrance for the parties who are leaving the business and moving ahead for commercial reasons. A non compete and non solicit clause is seen quite often in employment contracts and the contracts relating to the acquisition of businesses. In this chapter, we will try and understand the meaning and intent of these two clauses. We will also try and analyze the legal position of the clauses in India and then try and analyze if the inclusion of these clauses in commercial contracts is permissible, and if yes, then to what extent. Just to add a clarification, we will just be looking at the very basics of these two clauses in the context of Indian law and will not be going too deep into the areas such as M&A, competition law, and such other areas which are more complex and may need much deeper analysis and discussion on the subject. So let us first understand what does non-compete and non-solicitation means. A non-compete clause typically creates a restriction towards one party in engaging in certain types of activities. In the context of an employment contract, these may be in the nature of restrictions on working with a competitor or engaging in same or similar business activity. In a typical employment contract, the clause may be in the nature of putting restrictions on the employee while being in service as well as after the termination of the employer-employee relationship. Such clauses may restrict an employee's ability to engage in the same/similar business activities as that of the employer while being in service, and for a certain period even after the termination of the employment contract. On the other hand, in a commercial contract which deals with the sale of a business, it may be in the nature of putting in certain restrictions on the seller of the business not to engage in the same business activity for a certain period of time and within certain geographical territory if if that business is physical in nature and geographical territory is relevant to the business. In similar vein, non-solicitation is a clause which is in the nature of restrictions which impair the ability of a party to approach the teams, employees, or customers of the other party to the contract. The intent behind the inclusion of these clauses in commercial contracts is to give the ability to a party to protect its business interests, customers, and employees on whom it would have made certain investments in training, etc. Now, let us look at the relevant provisions which deal with this subject in India. The provisions of Section 27 of Indian Contract Act read as follows. It says, every agreement by which anyone is restrained from exercising a lawful profession or trade or business of any kind is to that extent void. While creating this provision, it also carves out an exception to the provision and says that one who sells goodwill of a business with a buyer to refrain from carrying on a similar business within specified local limits so long as the buyer or any person deriving title to the goodwill from him carries on a like business therein, provided that such limits appear to the court reasonable, regard being had to the nature of business. Now, the clause is in line with the provisions of the Constitution of India as well, which under Article 19 guarantees a fundamental right to every citizen to carry a legal business or profession. So, if we do a bare reading of the provisions under the Contract Act, it may suggest that any clause which can be said to be in restraint of trade is void and therefore unenforceable under the provisions of Indian Contract Act 1872. For example, the restrictions to engage in a competing trade or commerce while being in employment may not be termed as something which is in restraint of trade, because obviously you are continuing in that employment and therefore you are allowed to carry out a legal trade. But extending the scope of this clause beyond the term of the employment contract may in certain cases be construed to be restrictive in nature, because then even after termination of the contract you are restricting the employee from engaging in some legally valid trade or business. Now, does that mean that a non-compete and non-solicit clause in an employment contract is always void? I would say no. Over a period of time, the courts in India have applied the test which is called as the reasonableness theory whenever they have considered the disputes relating to the non-compete clauses in an employment contract. One must understand that, especially while considering the validity of a contract, the courts in India also give a lot of importance to the position of respective strength that each of the parties to the contract exert. Typically, in an employment contract, an employer will always be considered as a party with substantially more authority and power than an employee. And therefore, while interpreting a non compete clause in an employment contract, the court may tend to lean more towards an employee favored opinion. Having said that, the courts in India in a few recent cases have given due consideration to the fact that the clauses, if not overtly restrictive and if reasonable in nature, may be enforceable under law. The term reasonableness here, in the context of employment contract, is in most of the time connected with the restrictions which are imposed on account of goodwill. We saw that section 27 of the Contract Act also in the nature of sale of business carves out goodwill related sale. Also, if it is relating to or connected with the trade secrets of the business and confidential information and confidentiality of certain business specific secrets which are proprietary to the employer, and if restrictions in terms of non-compete and non-solicit are placed connected to these few things, which is goodwill, trade secret, confidentiality, and the proprietary information, then in such cases there is a possibility that the courts may term them to be reasonable in nature. Also, in certain cases, as I said before, the reasonableness in the nature of time and jurisdiction or the physical extent will also be looked at. So, a contract which prohibits an employee from getting into a similar or same business or competing business forever is an absolutely unreasonable clause and will not sustain the test of law. Whereas, if it puts reasonable restrictions of, say, a period of few months after the termination of the employment and is also connected with the access that the employee had to the trade secrets and confidential information and goodwill of the company, then there are possibilities that the clause may be termed as legally enforceable clause. Now, in the context of commercial contracts, such as sale of business or transfer of business, the view may be slightly different, as in these contracts, the parties to the contract exert almost same or similar authority and power. The exception provided in section 27 of the Contract Act, which again spoke about the sale of goodwill, is specifically for this reason, because both the parties are almost same and similar. Uh, uh, Parties have similar authorities under the contract, and uh, the transaction is actually happening towards sale of a goodwill, and some consideration is being paid for the goodwill. So restrictions around that may be termed as reasonable. There are some also other examples in India where some statutes or regulations provide some bit of scope on non-compete by expressly recognizing certain aspects of a non-compete. For example, SEBI Substantial Acquisition of Shares and Takeover Regulations 1997 recognize payments which are made towards non-compete, which means they are carving a scope for non-compete restrictions to be placed in commercial contracts which are in the nature of acquisition or uh, takeover of shares and those kind of contracts. Of course, these clauses also will have to be uh, tested on the touchstone of reasonability. In terms of commercial contracts, the test of reasonableness is slightly more towards public policy, which is, say, for example, not creating any restrictions which are unfair towards the competition in the market. But otherwise, the reasonableness test remains the same as to time, the territory, public policy, not anti competitive or not against fair competition, etc. So, in a nutshell, clauses such as non compete and non solicit, which are restrictive in nature, will always have to stand the test of reasonableness to survive and enforceable in law. So, whenever you draft or vet such clauses, be mindful of the fact that it cannot be overtly restrictive in nature and in the nature which can be considered as restraint of trade. Thank you so much.